And we're live. We were just talking about Jeff Dougherty, who is a trial consultant. How are you doing today, Jeff?
Doing great. How about you?
I'm doing fantastic. Now, you were just telling me that the majority of people you deal with probably do worse than they think they're doing when you have to prep them.
Yeah, well, yeah, like we were talking about, it's amazing how what people do when they go into a deposition or trial testimony, they've got a certain skill set that they're used to that works, that's always worked for them in life. And so a lot of times people think, hey, I know what I'm doing. I'm a good communicator. I've got a good skill set. I'm a professional. I can handle this. I know what I'm doing here. Why do I need somebody to come in and to tell me? I mean, all I have to do is tell the truth, right? Why do I need somebody to come in here and teach me how to tell the truth? But without question, every single person that I've worked with, from the CEO of a company down to, it doesn't really matter, a line staff person,
All
everybody needs
right.
help. Everybody needs help.
Let me just ask. KCD is on, and Kay, it is actually live. So ask any questions you have. I would love to hear from you. What is the one skill or what is the one trait that people should focus on when they're going in and they're going to be questioned by a lawyer or for a deposition?
Well, that's a great question. There's a lot that they need to focus on. So, like, I think when we talked before, I mentioned that anytime I work with a witness, I spend no less than 6 hours with them. So to pare it down to the one thing,
I was wondering if it's humility.
no, it's well, that's a great point because there are some arrogant people, and if you come across as arrogant, jurors hate that stuff. They don't like
Mhm.
arrogant people. It's confidence is
Mm.
what's probably one of the most important things that a witness needs when they're going in to testify for a deposition or trial. What it takes to get that confidence, that's what the 6 hours covers. So a lot of it has to do with getting a witness to the point where we've reduced their anxiety, we've increased their confidence, we've given them tools so that they can be confident, and confidence um, instills in the jurors' minds competence. So if they see a confident witness, whether it's a deposition that is shown at trial or trial testimony in front of a jury,
Mhm.
if the witness demonstrates confidence, then they're perceived as a competent person. And confidence just engenders good feelings and trust and that sort of thing. I mean, you believe people who talk and behave and engage with their bodies and with their tone of voice in a confident manner.
So it implies truthfulness almost. I've had a body language person on. She was talking about when people are speaking truth, they sing. And I always thought that was an interesting way of looking at it. Like, their movements are flowing okay. There's no stiltedness. Nothing seems completely out of sync. Is that a similar situation where somebody's confident and steady and they're on message? They don't seem rattled in any way. It just feels more truthful.
Yeah, that's a great way of putting it because they're natural. They're not guarded. If some so witnesses they get nervous and they get anxious because it's a very stressful situation. So they become guarded a lot of times because they think, okay, what is this opposing lawyer? What is he going to do or she? What? How are they going to trap me? Are they going to trick me? Are they going to make me look foolish? Are they going to use my words against me somehow? Are they going to make me admit to something that I don't agree with, or get me rattled? All of these things, and also not to mention the fact that a lot of people they're in the midst of litigation, which is stressful as it is. Their
Sure.
reputations sometimes are on the line. There's so much going on, so they become very guarded, and that body language signals a lack of comfort and a lack of genuineness. And so that's one of the things that teaching witnesses how to be confident and giving them the skill set that helps them portray the confidence lets them be who they are. So, a lot of times people think, okay, a witness prep person is going to teach somebody how to act or how to be somebody that they're not. And that's the
Hmm.
last thing in the world we're going to do. We don't want to get somebody, or we don't want somebody to try to play a part or something like that. And I think that might be a misperception of my profession, is that, we go in there and we teach people how to maybe fool the jury, or teach witnesses how to be somebody that they're not, and to act a role or something like that. And really, it's the genuineness that matters, probably, which, confidence. If you have confidence, you can be genuine. And when jurors see somebody who's genuine, they look natural. They look like they're not spinning. They're not afraid of the questions. They're not perturbed about the idea that they have to answer questions, even from a very aggressive lawyer. They're they're at peace, and that lets you behave with your body the way you would in a normal everyday setting with a friend. And when jurors see that, they think, okay, I think I trust that person. I think that person is being honest with me. But when they see somebody who looks like it's scripted, we talked about this last time, scripted testimony. When they see that, it's obvious. The tone of the voice, like you said, the sing-song kind of tone of voice. When somebody's got their testimony memorized, or they've got canned phrases that they feel like they have to insert in their testimony, it doesn't look real, and it's obvious to jurors. And it's jurors don't like it. They don't buy it, and they say. And what I hear a lot of times when we mentioned this before, I interview jurors all the time when cases finish. I call them up, and sometimes I'll reconvene them into a group, and I'll conduct a focus group with them. And that's one of the things that comes up over and over and over again. Oh, that witness was coached. That witness was scripted. That witness had their testimony memorized. They just don't like it, and they don't buy it, and they don't believe it. And what the sad thing is, they dismiss it. So that person may be the most important witness in the case. And if their anxiety gets in the way, or if they've memorized their testimony and the jury just says, you know what, I just disregarded all of it. Well, there goes the case potentially.
Well, cool. We got some questions flowing in, which is awesome. This is from Kimmy Z. Is it to also help them feel not bullied by the opposing attorney's questioning so they can answer honestly? I'm saying your role, I think, is what she's asking.
Yes, that's a great question, because what happens is they do feel bullied, because lawyers they've got a bag of tricks. And when they're deposing somebody, and for people who don't know what a deposition is, it's under oath testimony that the attorneys conduct with the opposing side's witnesses before trial. And that's where it goes back to, they already know what the witness is going to say essentially before they get on the witness stand, because they've already spoken to them for who knows how many hours. Could be 10 hours, could be 2 days. So during the deposition, what happens is the lawyer who's asking the witness questions is looking for places where they can push their buttons. Will aggression work? Will aggression cause this person to fold? Sarcasm, rudeness, or kindness. I mean, sometimes if you're really kind, then the witness just drops their guard and opens up and just starts disclosing all sorts of things, even if it's not bad information, it's just information that the other side doesn't need, and it just opens up more questions. So it's when the witness can go in with confidence, and if they've got tools. Because here's the thing: most witnesses have not testified. They're not skilled at the art of dealing with an adverse communication environment. They just live their everyday lives. They're not lawyers.
Sure.
So they're walking into the lawyer's world, and they know that lawyers have rhetorical tricks and traps and ways to trick them and to trap them and to make them admit to things and to break them down and so on. So if we can teach a skill set to the witness before they go in, so that they're armed with strategies to handle what's going to be coming at them, then they can be themselves, and they won't feel intimidated, because they've got a whole bag of their own tools that they can use in that environment, so that they don't get tricked, so they don't get trapped, so they can see through the gamesmanship, the rhetorical strategies, and the gamesmanship that the opposing lawyer is playing, and they're not fazed by it.
That kindness, though, you just mentioned, seems like maybe the most devastating technique of all, because it's hard to feel like you're being tricked if somebody is genuinely being kind, being open. That would seem to be a very, very effective questioning technique.
Well, I think it is. I mean, if I were an attorney, that's probably the strategy that I would use, because I don't like to be aggressive toward people. I don't want to be rude or sarcastic or demean people. I mean, it's really amazing what some of these lawyers will do. It's unbelievable how aggressive they'll get with witnesses sometimes.
They're pugilistic.
I'm sorry?
They're pugilistic.
I mean, they are. Well, that's what they're fighters. Exactly. That's what they they went into law because they want to argue for a living, right?
Mhm.
Most people don't. It's just not, we just want to live our lives, right? So if they encounter somebody on the other side who's supposed to be the enemy, and that person seems reasonable, they seem kind, that attorney can lure and lull somebody into a sense of, hey, this isn't so bad. They drop their guard, and then they just start talking and having a more like a conversation, and they get out of the role of being a witness, and they're not as vigilant as they need to be, and they end up making mistakes that they shouldn't make, and they wouldn't make if. So anyway, it's kind of that old saying that you attract more flies with sugar than vinegar, or something to that effect. I probably
Yeah.
got that wrong because I'm not from the
Or
South, but
honey or vinegar.
right,
There's a lot. There's also defecation or that. So
right.
there's other. We have a question from KCD. Can you please tell me what someone can do who is not a party to a case but knows that someone involved in a case has provided a false affidavit on someone else's behalf? Every statement is a lie. That's almost a straight legal question.
that really that's a question for Viva Fry. Actually, I hate to say it because and I
He'll
should,
be on next week,
yeah, and
next Friday in the daytime,
so
12 p.m.
Kate,
Eastern.
sorry, I interrupted you. Say that again.
No, I was just telling KCD, David, Viva Fry will be actually on next Friday at 12 p.m. Eastern if you want to keep this question and ask him directly.
Yeah, but so Kay, and I feel bad that I can't answer this question because most of the cases that I deal with are civil cases. So, um, provided a false affidavit on someone else's behalf. Every statement is a lie. I mean,
Oh,
the only, my first reaction is you can't really do much as a person who's not a party to the suit. The witness just has to be able to stand up to, if there are lies in the affidavit, and it's brought up to them, say in the case, that witness has to be able to um, respond in a way that shows that they're being truthful, and that has to do with their body language and demeanor and tone of voice when they're asked about these things, because jurors are looking for who's lying to me and who's not lying to me, who can I trust, who can I not trust. And so if a witness is confronted with lies and they have the wherewithal to be able to respond in a way that doesn't look defensive and looks calm and looks at ease, but affirmative denials of the lies, that goes a long way. So it's really about how the witness responds when they're being peppered with difficult questions or confronting something that's not truthful.
okay. There's
So
some
I
more
hope that
on.
helped, Kay.
There's some more from her on this. This person is in a video interview saying that they lied in the affidavit because Washington Post and New York Times favored a certain version of the story. This person contradicts every single statement too. I don't know, maybe the bailiff or the judge. I mean, that's a
And
weird.
that, right, if that person, so the thing about witnesses and testifying is you never want to lie, and you always want to be consistent. So if that person, whoever it is, ends up on the stand and has to testify in a deposition or at trial, and they're confronted with contradictory statements that they've made, their credibility is destroyed. So they may have just shot themselves in the foot if they said one thing one day and something else the other day, and that can be shown to them at trial, and then the jury looks at it and says, well, this person's just dishonest, I can't believe a word that they say, which happens to witnesses all the time. I mean, they
And
call
thank
it,
you, Kay.
yeah. Hopefully that was helpful.
Thank you very, very, very much. Kay was very kind and donated to the cause here.
Excellent.
Let's see. We have Eva. Eva brings up a good point. Testifying in court. I haven't done it in court, but I'm scared to go to court to do it. So I'm sure this is true. Testifying in court is scary. One thing I had a lot of problems with was talking too fast and over the lawyer. The judge had to warn me many times, something the lawyer didn't warn me about.
Yeah, well, that's unfortunate. That happens, and you shouldn't feel bad about it because it happens with almost every witness that hasn't been prepared properly. And when I say prepared properly, I mean prepared by somebody like me. I mean that might sound arrogant, but I'm not a lawyer, so I understand the human side of having to testify. And I've had to testify before as well. So, and you and I spoke about that offline a little bit. And so I know what it's like to have to testify. And so when you're on the witness stand, the anxiety is so high. And a lot of people start to talk fast and they're not thinking clearly. And the anxiety is causing their brains not to function, the executive functioning part of their brain to shut down a little bit. So one of the things that I teach witnesses, which is it sounds simple, but it's very difficult to do, is you have to separate the communication environment into three distinct sections. So when you're on, it's a tedious way of dealing with the questions, but it's very effective because it allows you to engage your brain. It calms the situation down. I'm going to go through it here in a second. But the effect is that it keeps you calm. It gives you time to think, and it helps you avoid the idea of or the prospect of speaking over the lawyer, because when the judge has to reprimand you, then your anxiety gets even higher. So what you have to do is you have to look at this communication environment of being cross-examined or deposition as a very piece by piece, drop by drop situation. So it's a patience game. You sit, you listen to the question, and you wait, no matter what, however long it takes until that question is finished. In everyday communication, sometimes we'll complete each other's questions and statements for each other because we think we know where the person is going. I mean, that happens sometimes. We just do that. But when you're testifying, you have to be patient. There has to be a pause between the time that the attorney stops asking the question and you start talking. And in that period of time, you have to ask yourself two questions. One is, do I understand the question? And you have to literally ask yourself that question, because a lot of times these questions are confusing. Sometimes they're two-part questions. Sometimes they're convoluted. Sometimes they're maybe they have a double negative in them. So you have to ask yourself, did I understand that question? And if not,
what if you don't? Do you immediately just say, I don't understand?
Exactly. Because what the witness's role is to tell the truth. And if you get a question that you don't understand, the truth is, I didn't understand that question. And what you don't do is you don't say, are you asking me this? Or did you mean this? Because you're just helping the other side out. You've got to make the other side work. You've got to make that lawyer work. And he has the obligation to ask you a fair question. He or she shouldn't be asking you double negative questions or two-part questions. So there's the listening part. You pause and you ask yourself that question. Did I understand the question? And then you have to ask yourself, and this all gives you time. Your brain can do this really rapidly. As I'm going through this, it's kind of methodical and it seems like it's taking too long. But you also ask yourself, is this a fact question or is this a question that it requires interpretation or analysis? So a fact question, for instance, would be like a yes or no question: time of day, person, a name of a person, place, those unchangeable things. So if it's a fact question, you're safe at giving a yes or no answer. But if it's an interpretation question, like for instance, wouldn't you agree with me that in this situation, X should always happen? Well, it sounds like a yes or no question, but the true answer is probably not yes or no. And that's where witnesses really get stuck, because they think, okay, he just asked me a yes or no question. How am I going to answer this question by being truthful, but not saying yes? Because once you say yes, you're stuck with that forever. And now you've boxed yourself in. So you ask yourself,
how do you do that? Because in cross, don't they do that deliberately, where they're boxing you to say yes or no, blah, 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 blah.
Right. But the beautiful thing is that you don't have to play that game. That is part of the rhetorical strategies that lawyers use against witnesses. It makes the witness feel uncomfortable, because the witness feels like, I have to say yes or no. But what if the answer is, well, it depends on the circumstances. Sometimes yes, sometimes no. Because that's the way life is, right? Especially on something that's not factual in nature, like something that's unchangeable. But in things that we do every day, we don't do it the same way every day, every time, no matter what, in every circumstance. We do things differently. And so witnesses are afraid to say, well, it would really depend on the circumstances. Like, so for instance, you get a question, well, wouldn't you agree with me that in this situation, a reasonable and prudent person, say a truck driver, should always do X? Mm-hmm. Not necessarily. The answer might just be not necessarily. Now you're not trapped.
Okay.
That's perfectly okay. Well, the beautiful thing about it is it's perfectly okay, and it's truthful. It's more truthful than yes, because if you say yes, the truth is that maybe sometimes yes is not right. Now you've boxed yourself into yes, and then what they're going to do is use a situation down the road to show that you've that you have contradicted yourself somehow, and that you just said over here, you always do this in every circumstance, always, and a reasonable truck driver should always do X. And then they'll bring up a fact out of the case where that didn't happen. And now you've just shown that what you did doesn't comport with what you said you always should do or a reasonable truck driver should do. And now you're stuck.
Okay.
So the tough thing for witnesses is to be okay with the idea that a truthful answer is, I don't agree with that, or sometimes that's true, not always, or that's not necessarily true, or in certain circumstances that's true, but not always, and just leave it at that.
Okay. As we're going with the questions, we're also going to be doing some of these like examples and just kind of talk through them. I think this is an interesting one right now. It's Bill Gates, and he's being asked some questions. And I'm wondering what you think.
Exhibit 353 starts with an email dated December 1, 1996 from Mr. Ballmer to you, correct?
There's only one email in here, which is the one from Steve, which has 2 emails enclosed in it.
Well, what is enclosed here are 2 additional emails, correct, sir?
They're part of Steve's email.
That is, Steve, and by Steve you mean Mr. Ballmer, correct?
Yes.
Is sending around with his email 2 earlier emails, correct?
They're part of his email.
Well, when you say they're part of his email, he didn't write them, did he, sir?
No, but they're part of his email.
That is, he is sending them around. That's what I said 3 times. He's sending them around with his email. He wrote something, and in addition to what he wrote, he's sending around what 2 other people wrote earlier. Correct, sir?
It's part of his communication. It's not separate.
All right, I want to pause it here for a
I know
second.
what you mean.
Sure.
So what Bill Gates is doing frustrates jurors to no end. It's a simple question, right? He's asked, you received this email that had attachments of 2 other emails. All he has to do is say yes, because the lawyer knows he received it. It's not going to change anything. He just has to say yes, but he's quibbling over something that is so obvious.
Okay.
And when jurors just want people to concede the truth, you know, is this an email with 2 attachments? Yes. Did you receive it? Yes, I did. Because if this was a trial and Bill Gates was on the witness stand and you've got a bunch of lawyers in the jury box, a bunch of jurors in the jury box, they feel like their time is being wasted by this, quibbling over something that's inconsequential, it's meaningless, but Bill Gates is, and you could hear the frustration in the lawyer's voice, and it's not serving any purpose other than if this were at trial, the jurors would be really annoyed because their time's precious. You know, they're taking sometimes a month, sometimes 2 months, 3 months out of their lives to sit there on the jury. And when you got somebody like this wasting their time over something meaningless like an email, does it have 2 attachments? Is it 1 email or 2 emails, or what's the communication all about?
Mm-hmm.
I guarantee he would lose the jury.
Okay, so this is an example then of how not to. One time he could say yes or no and move on and not go and
because it's a fact.
Argue against it.
Right, it's a fact. It's not going to change. No matter how many times Bill Gates goes back and forth and quibbles with what it was, attachments, no attachments, 1 communication, multiple, it's not going to change the fact that he received it and it had emails from 2 other folks in it. Just move on.
Okay.
Just answer the question. Yes.
Okay. Sounds good. I'm not going to probably play all of the clips, but little pieces of it, because I thought that one was kind of on target with what we were discussing about whether to say yes or no, or what would be good examples of that.
Well, and let me just mention something really here. So Bill Gates obviously is a smart guy, so he thinks he's outwitting the lawyer.
Right.
It's not serving any purpose whatsoever. It's not furthering his case. What it's doing is making him look bad, because if the lawyers take that clip and they show it to the jury's just going to be annoyed by it. So
actually, that does continue with some more on that when you're talking about the outwitting, because I'm skipping ahead a little.
Yeah.
He only sent one thing.
All right, sir. The next line says, sent Sunday, December 1, 1996, 9:25 p.m. to Bill Gates, Amir Nehru. Correct?
Did you say 9:25?
Well, on 353, it looks like 9:26.
Right. And you said 9:25.
Okay, then I misspoke.
So I didn't look at the timestamp on that. I mean, that clip is 2.5 minutes, but I think that's cobbled together some clips of that portion that
Well,
lasted.
I
Yeah.
skipped over a chunk just now because
Right. Totally unreasonable and unnecessary. It accomplishes nothing. It just makes Bill Gates look bad.
Okay, so even the quibbling over the time was a Pyrrhic victory or Pyrrhic victory.
Yeah, it just doesn't do anything whatsoever. I mean, it's okay to point out, oh, yours says the 25th, mine says the 26th. Do we have the same document? That would be fine. But that was just part of his whatever strategy he thought he was employing, being super smart. Hey, I'm smarter than you, and I'm going to parse this thing out until the cows come home. I mean, nobody likes it, and it doesn't accomplish anything. It's worthless. And the funny thing is that people think that they can short circuit the depositions by being super smart or outwitting their opponents. It just makes their depositions last longer, actually.
Okay, well, while we're on that, we'll have some fun with this. Then we're going to jump back into the questions. You and I were talking earlier about sometimes your hardest, I guess we'd say, clients are actually lawyers themselves.
Yeah. Oddly enough, right?
So we have an example here of a gentleman being questioned, and I believe he is an attorney himself, and he's trying to school the questioner or something.
And that it's going to lead to non-discoverable evidence under the rules of evidence.
Mr. Abrams, you are not allowed to. I am allowed to interrupt you. This is my
he's giving his answer.
Sir.
You can't. It's
And
my answer. This is my answer.
You are not allowed to put objections on the record. You are a witness today. And Mr. Abrams, you are represented by counsel. Your counsel is allowed to put objections on the record. You are not today.
I am a lawyer.
Do you understand that?
I am a lawyer. I don't need a lecture from you who doesn't understand the rules of evidence. Under the rules of evidence, the only thing that can come in under the rules of evidence is truthfulness and untruthfulness. So to the extent that you're trying to disparage me because you have me on videotape and embarrass me for things that you can't bring in, I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30.
Hey, let's stop it here really quick.
You don't know it.
But I think we should continue playing it because it's fun to watch. I mean, so you see this. I mean, strike number one against this guy. He's a lawyer. So
well, yeah, that's automatic strike. I agree. That's just as a measure of humanity. They're a lawyer. They're striking. Now, if he's an accountant, I don't know.
Right, right. Well, it would be bland if now we're going to alienate everybody here. But so he's behaving like an arrogant jerk. He's making his lawyer's job difficult. So he's hired a lawyer, and he needs to let his lawyer do his job. Instead, he's acting like a lawyer. He thinks that he's smarter than everybody else in the room. You can see it in his tone of, in his facial expressions, in his body gestures, in tone of voice. Just everything about this guy just reeks arrogance. The thing about lawyers is, as witnesses, they're probably some of the most difficult witnesses to prepare for testimony, because they can't take off the lawyer hat and put on the witness hat. And again, that's why I get hired all the time to prepare lawyers for their depositions and trial testimony. And they can be some of the most challenging clients, but they can also be some of the best clients because they're smart. And once they get it, it's kind of like freeing their minds. They don't have to think like a lawyer. They don't have to strategize. They don't have to raise objections. They don't have to think 10 steps ahead. All they have to do is answer questions. So this guy, he's getting emotional, which isn't good, because he looks like an arrogant jerk, and he knows that this clip can be played for the jury. He even acknowledges it. He says something about you're trying to embarrass me by capturing this on videotape, and so on. He knows that it's being captured on video, and that it's likely to be shown to a jury. And if the jury sees that, they're not going to listen to him. They're not going to like him. And likability and believability go hand in hand. So if you don't like somebody, and if the jurors don't like this guy, it doesn't matter what he says. He could say everything 100% truthful, and everything he says can be powerful testimony. But if he says it in the way that he's testifying, it's worthless.
Okay.
And he's making his lawyer's job more difficult because he's objecting, and his lawyer is the one who should be objecting, and he's just making the record a mess, and he's arguing, and it just serves no purpose whatsoever other than to make him look bad. But it's fun for us. Right?
He's going to keep right on
I
driving.
feel quite confident that if any sanctions are entered in this matter, it's going to be against you.
Objective form.
For continuing to obstruct and not answer any of my questions.
Objective
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished. If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3
We're
sections.
going to move for harassment sanctions against you right now. Okay, you're laughing at us with the videotape that you published on the internet about you and your rock band, and you're going to be laughing at me.
Look at that
And you
smug.
moved for sanctions and had them denied every single time.
Yeah, let's stop there for a second. Look how smug this guy is.
Oh yeah.
Nobody likes smugness, and you could just see it in his facial expressions, and he just thinks that he is so much better than the opposing lawyer, and he probably thinks he's smarter than his own lawyer because he's not letting his own lawyer do his job.
He's hilarious.
Yeah,
in his own mind.
it's funny to watch, and the funny thing about it is, I guarantee he is doing everything he would instruct his own witnesses not to do. He's violating every rule about what it takes to be a good deponent every step of the way, and he's harming his own case. But his ego has gotten in the way, and he's not letting his own lawyer do his job, and he's not taking it. He's not taking off the lawyer. I always call it the lawyer hat, putting on the witness hat. All he has to do is answer the questions and be personable and be likable and tell the truth.
Actually, if he was serving as a lawyer right now, he's not very likable.
Right.
I mean,
Yeah,
he's just not a.
He's all over the
He's
place.
All right, so we'll roll a little bit more.
And you moved for sanctions and had them denied every single time in this matter, and the jury should see that too. Every single one has led to no sanction.
Mr. Abrams, are
Including
you
the last
aware?
one where we quashed all of your subpoenas. And you asked for attorney's fees and you got no sanction.
Mr. Abrams.
Let's move on. Do you have a question for me? You sued my firm belligerently.
He can't
under
stop.
The abuse of your law license, where we countersued you. We have.
But we have to.
Yeah. It's unbelievable. It's really amazing though, but it just shows how difficult it is because and I do have to show a little bit of empathy because, like I said, I've had to testify before and I've been sued before, and I know what it feels like. You get emotional. It's very difficult to take the personal piece out of it and to be objective about it, and just to his job there is to answer questions, and that's it, and to tell the truth.
Okay, well, as
But-
a counterpoint, I think you had stated before that this might be somebody doing okay.
We are now on the record in the matter of Big Cat Rescue Corp. versus Big Cat Rescue Entertainment. This is the videotape deposition of Joe Schreivogel. Okay.
All right, now that's really short, and it's kind of funny that of all people that you said, hey, we're about to show you a clip of somebody doing well, and it's Joe Exotic.
Of course. Why not go for the ridiculous? So I mean, the other guy is the lawyer. Why not go for the crazy?
Right. Well, so the thing about that clip that I like is that Joe can he can have some charisma and he can be likable. I mean, I don't know if you watched Tiger King. A lot of people probably did, and he goes off the rails. Obviously, it's craziness. But what I liked about that clip is that he was pleasant. He smiled. He was patient. That court reporter struggled with his last name a little bit. He let the guy give it an attempt. He corrected him politely. He was polite about it, and he just smiled. And he was likable. I didn't really like what he was wearing for the setting.
Yeah.
I mean, if I had worked with him, I would say, listen, you don't have to wear a suit, but wear a polo. Don't wear the hat. Just be professional. Just take the professionalism up a notch or two here. Again, he doesn't have to be somebody he's not, but he should respect the process and maybe dress a little bit better. But the demeanor, the body language, the tone, it was great.
Okay. And next question we have Kimmy Z. Sounds like attorneys have learned the art of reading body language of those testifying so they know what buttons to push and get the desired results. Agreed?
I do agree. That's they know that a lot of times what the witness actually says is not as important as how the witness says it and how they're perceived by the jury. So they have over the years acquired a like I call it the bag of tricks, to learn, well, what is going to get this witness to look bad? I have to let my dog out. Hold on for a second.
All right. Everybody can hear that scratching in the background.
There, that was quick. He was
Oh,
just
that
right
was
here
quick.
at the door. He's trying to get out the door, and he was getting more agitated.
Perfect.
So they know that it's, the content is important, of course.
Mhm.
What a witness says is important. The truth is what matters. And I just want to say, and I always say, every witness that I meet with, one of the first things I tell them is, we're not ever going to ask you to say something that's not true. We want you to tell the truth, but we just want to help you tell the truth in an effective way in this environment. And that's the challenge. So lawyers, to the question, they've learned over the years, in their practice, how they can get underneath the skin of their witnesses and what is going to cause them to either fight back or to fight. We talked about the fight or flight scenario, or fight flight. I say fight, flight, or freeze, because a lot of times what happens is people just lock up.
That is actually part of it. I mean, freezing is lizard brain. So
Right.
it is fight, flight, or freeze.
Right. So
on.
so the lawyers are trying to find, can I do this to a witness? And if I can, I'm going to get them out of their logical, rational brain into anxiety and fight or flight mode, and they won't be thinking clearly, and they might either argue with me, they might become sarcastic, they might freeze, they might not know what to say, and that looks bad on videotape or looks bad in front of a jury. So that's a great question, and I think that's exactly right. Lawyers know how they can get witnesses to feel uncomfortable, and they know if they can make a witness feel uncomfortable, it's going to make the witness really struggle just to tell the truth.
You made me think of something. One of the biggest fears in the world, actually, it's the fear ranked above death, is public speaking. Do witnesses often feel that, and do lawyers sometimes, are they able to take advantage of that? Because you are literally up there speaking to the public, and that's not comfortable to a lot of people. And there's been some research on that. The reason why there's a built-in fear of public speaking is the only time people spoke in public for a couple 100,000 years was to defend their life in front of the Klan. Well, in this scenario, isn't this a similar thing?
That's a great point. And, and that's one of the things that we address when we work with witnesses is we understand that they're coming in anxious. And it's even worse than just public speaking. Let's say in college you have to give you're in speech and debate, or in high school you got a speech class. You prepare your speech in front of the class. Everybody else is going to do it too. So you're all in the same boat together. And the consequences aren't that high. I mean, you've got a little bit of social stress with the rest of your classmates there, but the consequences in public speaking in the court setting are astronomical sometimes. I mean, it could be your freedom. It could be your life, right? Or it could be
your business,
tens of thousands. It could be your business. It could be everything, right? So you've got the stress of a lot is riding on this. You've already been through years of stress because litigation lasts for years and it really sucks the life out of you. So you're already dealing with a lot of stress. Now you've got a judge in a black robe, elevated on a bench. You've got a group of people who are judging you, 12 jurors in a jury box. You've got potentially people in the courtroom observing, everybody in suits and dresses, dressed really nice. And it's such a formal setting that most people aren't accustomed to. So it's public speaking in a very stressful environment. So it's exactly spot on. That makes it very difficult. And that's we talk a lot about lying behavior. We talked about this before, that
Mhm.
jurors and lay people think they're good at lie detection, right?
And there's been
But
some surveys on that, and they're not.
right, they're not. They're good as a coin toss, basically. And even the experts they're good at it in the right environment, in the right scenario, and if they can get a baseline, and if they can do it in a very controlled environment, and compare what is the person like in this scenario, and has something changed in the way they're responding under this other scenario, and
Sure.
they've got tools at their disposal to be able to analyze people in maybe in interrogation settings. But lay people and jurors, they don't have the baseline. But what they do have is this person nervous? Do they? And so it goes back to what people typically think is indicative of lying. Like we discussed in the past, it's the anxiety of being on the witness stand. Not forces, but it causes people to exhibit behavior that looks like they're lying. And my job, it's a tough it's a tough job, is to teach people a skill set, and to find where the anxiety where their anxiety is, resolve it to the extent possible, boost their confidence, get them up on the witness stand looking confident, looking at peace, so they don't exhibit those behaviors like sweating or fidgeting or rocking in their chairs, or all those things that it's just basic nervousness causes.
Actually, I don't. We can show this again. I don't mind that I've shown it before. It's only a minute, but I think
Did you commit domestic
does a good
violence
job.
against Johnny Depp?
Anytime prior to May 22nd, 2016.
Yeah, look at her eyes.
Did you ever commit an act of domestic violence against Johnny Depp?
Calls for a legal conclusion and irrelevant, but go ahead.
Do you understand what I'm asking you?
No.
No?
Yes, I understand what you're asking me.
Now, right
Well-
there, when she said the no, I would worry too. Somebody could interpret that like she was being a smartass with the tongue going to the side. I'm not saying she is. She probably was saying, no, I didn't, to thinking of the other question, but was confused on the second question that came down, like a compound question. But could a juror interpret that maybe even incorrectly, that she's being a smartass? Do you understand? No.
I think
Yeah.
I think you're right. I think they could, and everything leading up to that too. Her eye shifting. She's looking around the room. She doesn't look calm. She looks like guarded, and she looks nervous, and she's shifty. And then she gives the weirdest response. That no was such an odd response. And that goes back to, she didn't process the question, like I was talking about earlier. You got to sit and you got to be patient. You got to ask yourself, did I understand what they were asking me? So it appeared that she didn't quite understand what the question was, because she went back and changed her answer after
And
the
that
lawyer
tongue
re-asked.
thing,
The tongue thing is really weird too,
no.
right? And that's something that I can guarantee jurors would look at. I can't guarantee it, but in my experience, after talking to so many jurors, they would be hyper scrutinizing her facial expressions, the way she behaves, her eyes, her shifting gaze, and they would be inferring that that's because she's lying. Jurors always say, and I've heard this so many times, jurors will say, hey, you don't need to be nervous if you're telling the truth. The truth will set you free. Just get up there and tell the truth, and you'll be fine. So if you're nervous, it must mean that you're lying. And if you're shifting around, if your eyes are going from one place to another, that means you're nervous. Therefore, you're lying. I mean, it's this calculation, that the assumption that jurors make based on very limited information. But again, the jurors have a tough job to do.
Right. And to continue.
And prior to May 21, 2016, or May 22, 2016, is it your testimony that you never committed any act of what would be considered domestic violence against Mr. Depp?
Calls for a legal conclusion and irrelevant to these proceedings.
I did my best to defend myself and not get seriously hurt.
Okay, pause it there for a
Or be
second.
doormat.
She's all over the place. She's not even answering the question. So she says, is it your testimony that you didn't perpetrate domestic violence against Mr. Depp, or something to that effect? She just has to say, yeah, that's my testimony.
Or no, I didn't.
Yeah, or no, I
Because-
never, I did not commit domestic violence against Mr. Depp, or whatever the answer is. But she starts to shift. She's moving around. She's looking around. She looks uncomfortable, and then she mumbles some weird answer that doesn't really answer the actual question. And jurors look at that and they're like, just answer the question. It's an easy question. Just answer it. Did you or did you not? But this dancing around the topic is like a key indicator to jurors that something's going on here. I don't think I trust this person. Oh, one other thing I wanted to point out. So when she said, back to that before we stopped it, she answered no, but she nodded yes.
Yeah, that's one of those popular tells if you watch Lie to Me and everything else.
Right.
But I will say out loud, because I think it's very important people realize, a nod when somebody is saying no can in fact mean an emphatic no.
Right.
So you've got to, it may look like one thing, okay, you're nodding instead of shaking your head, but it's the opposite that would be more confusing. Sometimes
right.
being emphatic, you might nod forward and say no.
Yeah, and the thing about it, whether or not she's lying, it's really hard to know. We don't know for sure. Only she knows if she's lying. But what my role would be is, before she even gets into that deposition, to find out, well, what is it that's going to be her difficult topics that's going to cause her to look like she's uncomfortable and lying, and to make sure that we address it and find out what's going on. Why? So, like, let's say we were practicing. Let's say that was a practice session, because what we do is I prepare witnesses, I train them, I teach them about communication strategies, and try to resolve their anxiety, make sure that I understand where they're coming from and where their trouble areas are. And then we make them practice. And if that were a practice session, I would have stopped right there and said, hold on for a second. To me, something doesn't look right. What were you thinking right then? And we just put the practice aside, and she just talks. Well, here's what I was thinking, or here's what I thought, or maybe I misunderstood the question. But job is to figure out what is causing that person to do something that's making them look nervous, or that is making them actually nervous.
Are they safe to talk to you, though, under attorney-client privilege, though?
Say that again?
Are they safe to talk to you freely under attorney-client privilege? I mean, did they ever have to worry about, I hate to say, well, what if they really are guilty?
Well, that's a great question. So it's, not being a lawyer, I do know a little bit about this, but I this isn't coming from the mouth of a lawyer. So there's the attorney client privilege, but there's also something that supersedes that called the attorney work product doctrine. Mm-hmm. And so when I meet with any witness, I always make sure the lawyer is present. And so if the lawyer is present, everything that I do falls under the umbrella of the lawyer and what he's doing, and his thoughts and impressions and preparation for the lawsuit. And I'm part of that. So it's not what we call discoverable. So the other side, a lot of times what will happen in a deposition, the other side will, or the lawyer asking the questions to the deponent will say, what did you do to prepare for your testimony today? So they're entitled to know, I met with my lawyers, but they're not entitled to know what they discussed while meeting with their lawyers. And that has to do with what I'm doing as well. So they're, the witness can disclose that I was in the room or that I was with them, but they can't disclose what we discussed. Or the other side's not entitled to know what it is that we discussed, because it falls under that rubric of it's the work product doctrine. So, and then the attorneys with their own witnesses have the attorney-client privilege. I don't think me being there waives the attorney-client privilege if the witness says something that could be incriminating. That I just don't know.
Well, I was just wondering, because I'm thinking that prep, especially if you're saying, well, why are you stammering or something? Okay, on the record, I think she was definitely deceptive.
Mm-hmm.
Just genuinely, I do feel like she came across as deceptive. Maybe I'm wrong. I'm not an expert like others I have on, but she doesn't look good. I can imagine you prepping somebody and they're saying, I'm afraid that I may look like I did such and such, maybe as a way other than directly telling you, but they can go pretty far down a path.
Yeah, that's a great point. And that's where, people will probably be surprised to hear this. Every lawyer that I've worked with has always emphasized how important it is to be truthful. They want to know the truth from their witnesses. They don't want witnesses to hide things. They don't want witnesses to skirt around topics. They want to know what the truth is so that they can handle it and figure out how to deal with that fact, even if it's a bad fact. So let's say, for instance, she did strike Johnny Depp.
Mhm.
Maybe it's perfectly reasonable. And when the story comes out on the witness stand, the jurors are going to be thinking, man, I would have done that too.
Mhm.
But instead, she seems to be trying. I have the impression that they had some sort of altercation and that maybe she did hit him in some way. I don't know, obviously, but I feel the same way you do. She looks like she's being deceptive. I'm only a human being, and I'm trying to interpret body language, just
Sure.
like anybody else would. But if she did hit him, maybe it's totally justifiable, and you can tell the story in a way. So I'm not as afraid of bad facts. What I'm afraid of is a bad fact coming out that we didn't know about. So I would rather, and the lawyers that I work with would rather know everything. They want to know everything so they can deal with it and figure out how to deal with it and figure out how to talk about it and how to, what is the narrative that's going to make sense for a jury so that, it doesn't, it could be totally justifiable for her to strike back. Right.
Okay. Well, sure. Or if she felt threatened, or he had a knife, or he could have had a knife, or he was incredibly intoxicated and he was going to belt her in a second. And there's a
Right.
million reasons.
Right. It's best to know than to not know.
Oh, definitely. Definitely. So let's go ahead. Got some more questions. I'll jump in here. Samantha Schofield. And Samantha is a member. Thank you very much, Samantha. That helps a lot. On what grounds would lawyers think you would not serve as a good juror? I don't know.
That's
That might be a Viva Fry question. I don't know.
Well, no, it's a great question because one of the things that I do is I help lawyers pick juries.
Oh, perfect.
So, and I do it from the psychological standpoint. So what we're always looking for in jury selection is, there's a process called, well, depending on where you live, voir dire. If you're in Texas, it's voir dire.
Or if you watch Barnes, Robert Barnes mutilates it.
Yeah.
Lawyer.
Yeah, exactly. It's wherever you are in the country, it's pronounced differently. It's kind of interesting. It's French. Or it comes from the Latin. Regardless, the point is that during the jury selection process, they call that voir dire. And my role is to help the lawyers ask questions to the potential jurors that will get them to start speaking and highlighting their attitudes, beliefs, and feelings that we think are risky for our case. So, like, let's say I'm working for, back to a trucking case, for instance. A truck driver gets into an accident and a family gets killed. Well, we want to find people on the jury panel who either have negative impressions of truck driving, they think trucks shouldn't be on the road, they've had bad experience with truckers, or large corporations, or so on and so forth. So we're trying to craft questions for the lawyers. So when the lawyers get up there and ask 50 people, sometimes they have limited time, like an hour maybe, to find the most dangerous people. So to answer the question, it's really somebody who has a bias, some form of bias. And this is a bias, not like racial bias, but a bias that's going to cause them not to be able to be a fair juror given their life's experience surrounding this whatever type of case it's on. So anybody who's got something that might make it difficult for them to just be impartial. That's
as long as it's impartial, as long as they're not partial towards you. But even that could be a problem because then the other side will kick them, right?
Well, that's the thing. I mean, we jury selection is a very frustrating exercise because you start off with 50 people, sometimes 100 people, sometimes more, and you've got a limited time to ask these questions. And we're hoping to keep our good jurors, what we call our good jurors, the people who we think are going to support our side. Mm-hmm. And we're hoping to get rid of the bad jurors. And the other side's doing the exact same thing. So ultimately in a perfect system, we ask the questions and we find the biased people that are not going to be fair inherently, and we dismiss them, or we get the judge to dismiss them. And the other side does the same thing. And so we're left with a group of impartial people. I mean, that's the way the system should work. I mean, the way I look at it is I'm hoping that we can hide our good people, and the other side doesn't find them, and we can get rid of all of the bad people I say bad, I just mean people who have
Right.
opinions, beliefs that are going to be adverse to our client. So
Sure.
that's really what it is. There's a long way of answering the question that lawyers are looking for, and we're looking for people who we think for some reason, based on their life's experience, their attitudes, beliefs, and feelings, the way they see the world, or the way they think the world should work, is going to cause them not to give our client a fair shake.
Okay, this one's a hard question from Sally Man Cox. How do you prep someone who has buried a traumatic event? Or even
Well,
I'll go further, or even somebody who suffered one. Buried, unburied, traumatic period.
yeah, well, that's it obviously would depend on what the traumatic event is, but I've dealt with some witnesses that have suffered some difficult challenges, and the thing that I have to do as a trial consultant is I have to gain the trust of the witness before anything happens. So I have to build rapport with the witness, because I'm somebody they don't know. The lawyers have called them in and said, "Hey, listen, we're gonna prep you today or tomorrow or however many days we're gonna work with the person," and then I show up. They don't know me, and I've got limited time to work with this person. And my goal is to find out what it is that's going to make their life difficult on the witness stand and resolve it. And when it comes to trauma or difficult life experiences, if I don't have their trust, if I don't build rapport up front, they're never going to open up to me. And it's amazing how powerful it is when I do gain the trust of a witness. And sometimes that'll take an hour, 2 hours, or longer. I mean, I'm going to spend as much time as I need to spend to build the trust so that I know that they are going to be comfortable opening up to me. Because unless they're comfortable opening up to me, I can never find out what it is that's going to make their life difficult and what we need to overcome and resolve. And so that's where I would start. It was building rapport and trust. And believe it or not, I don't know if you believe this or not, but some people don't trust lawyers. So, so they're called into a room with a bunch of lawyers and then me, and I have to kind of distinguish myself from the lawyers that I'm here for you. The reason why I'm here in this room with this witness is because I want to help you testify effectively, that I care about you, I care about your situation, and what I'm going to help teach you is going to make your life better on the witness stand. And I've got some tools that I can share with you and that I can teach that's going to make your life easier. And then when people open up, it's amazing. Somebody will walk into the room and they're guarded, their arms are folded, they're mad, they're frustrated, or they appear mad or frustrated or reticent, or they don't want to talk and they don't want to be there.
Sure.
But once you break down that barrier and you get them to open up and unload, sometimes they just need somebody to listen, because they've been in the midst of a lawsuit, and especially if it's been traumatic, that it's really devastated their lives. And oftentimes nobody's asked them the question, how has this affected you? And just sat and listened.
How do you prepare, or how do you be careful to not continue the trauma? Like, I mean, this is a very hard thing they're going through. And I believe you've taken a lot of psychology and things like that. Are you cognizant that they could leave more damaged than when they came in?
Right. I have a colleague, we call it breaking the witness. We worry about that. We think, did we break this witness? Did we ruin this witness? Are they worse now because of our involvement? And that can happen. And it happens when you don't give enough time to the process. So, lawyers are busy and there's always limited resources. So sometimes you've got 4 hours. I'd prefer not to take less than 6 hours. I would prefer a couple of days if I could, because if you can get somebody up to a point, but if time is over and you haven't resolved whatever it is, then they leave in worse shape than the way you found them. And now you've just harmed the case. And so we're very aware of that. And I make sure that I communicate that to my clients that, hey, listen, this person is not ready. If we don't meet with them again, they're worse. We have to meet with them again. And then you spend the time that you
choose, because I imagine you're going to have a boss, a lawyer who's paying you, and they need this in a case.
Right.
Do you ever have to take a stand and just say, I can't go there, or we cannot go there for the health or safety of the person versus their case? Because I feel like there could be a friction.
There could be. I haven't encountered that, but I do have to be honest if a witness isn't ready, I have to tell the lawyers this person's not ready. And that's that's the unfortunate thing is sometimes, they're so busy. Sometimes I don't get called until the last minute, the eve of trial sometimes. And if I've got limited time, and if they're testifying tomorrow, and I'm working with them today, I mean, it just does them a disservice. So, but I haven't, thank goodness, I haven't encountered a situation where I've had a witness that had something that's that sensitive that I was worried that we were going to go somewhere that's off limits, that we shouldn't go. If that makes sense.
Okay, well, while we're on safety, get through some more questions. Totally T, very interesting. Listening while driving, parked now. Thank you, Totally T. I definitely want you to stay safe.
I'm glad she wasn't typing out a long question while she was driving.
Yeah, I don't know if a hey lady in the tube works on this. Kimmy Z, a long pause before answering could be construed as trying to make up a story instead of giving a true answer. Yeah, you've done a lot of deception detection, things like that. Is it a matter of just as long as they're consistently doing that, that becomes part of the baseline so it doesn't feel deceptive?
That's part of it. Yeah, and that's a great question. That's a great point because people do interpret pauses, long pauses. Nobody's comfortable with a pause. I mean, we call it the pregnant pause. People feel uncomfortable. They want to fill the space with pauses, and people interpret a pause as, oh, this guy's making up a story. This woman's making up a story. But so you obviously don't want to pause too long. And that's why we practice. We practice getting them used to asking themselves those questions because our minds are very quick. We can ask those questions quickly. If we get accustomed to doing it with every question, and to your point, if that's the standard way that they answer questions, if their technique of answering questions changes between direct exam and cross exam, all of a sudden they're pausing super long. Well, that's not good, and that's inconsistent, and jurors don't like that. But what's more dangerous than pausing and risking people thinking that you might be construing a story is answering a question before you're ready. So you jump into a question, you get a question, you answer it, and you haven't listened properly. And then you admit to something that's not true, or you agree with some proposition that's not correct, and you agree with the other side's version of what the facts mean just because you haven't listened. And they're so crafty at asking these questions, in such a reassuring way. Well, wouldn't you agree? Isn't it fair to say that X, Y, and Z is true? They'll lay out a whole set of facts, and it's very difficult to say, no, I wouldn't agree. A lot of people agree to things that they shouldn't agree with just because of that setting. So it's safer and it's better to pause a little bit and ask yourself those questions and analyze the question than it is to fear the pause and answer too quickly and then admit to something that's not true. So you have to balance those two kind of competing ideas. But it is a good question. It's something I'm always cognizant of when I'm working with witnesses, because you don't want them to look dishonest after all the work that you put into getting them to ready to testify. And next thing you know, everybody thinks they're a liar because they're pausing too long.
Okay, and Eva brings up a good question. What if the judge asks, answer yes or no, please? Or would a judge not do that? Maybe, we're influenced by television. I know in television, it's like the witness will answer.
Yeah, well, here's what happens is a lot of times judges will be patient with witnesses, and judges really hesitate to jump in. They want what the jury's called the triers of fact. They're the ones that are making the decision. The judge doesn't want to insert himself or herself into the testimony if they can avoid it. So usually when judges jump in, it's when a witness has been kind of uncooperative and a question has been asked, and then the witness launches it by opposing counsel, and the witness launches into a long explanation that doesn't quite answer the question. It goes beyond the question, and it's really looks like they're avoiding the question. And then that's when the lawyer doing the cross-examination sometimes will appeal to the judge and say, could you please get the witness? Could you please ask the witness to answer my questions? They're yes or no questions. They're simple questions, please. But if you answer, say the question is, won't you agree with me that every time you get in your car, you should always turn the heater on? And not necessarily. Sometimes yes. The judge is not going to say it was yes or no question. Please answer the question, yes or no.
Okay.
So the key is being short and concise, and using the tools that keep you out of the box. Like, well, in general, yes, because we live up here in Maine and it's always cold, so typically I do, but not always.
That's an okay answer. Is you could say usually.
Usually, generally, but not always. And you just stay. You don't look. You don't want to look defensive. You don't want to look argumentative. You don't look like you're fighting or trying to get out of the answer. You just do it in an affirmative way. But you're actually being more truthful when you say something like, "Well, yeah, generally I do, but not always. Sometimes I do, but it would depend on the weather." This is a banal kind of trite example. I mean, nobody's going to ask that on the witness stand, but you can imagine a scenario in which a doctor is being asked, well, when you see this symptom, and this symptom, won't you agree with me that you always go to the differential diagnosis should be heart attack should be on there? You would agree with me. Shortness of breath, pain in the left arm. You see these symptoms, chest pain. If you see these symptoms, you should always think heart attack, shouldn't you?
And they could say it's a possibility.
You could say that, or you could say, well, it would really depend on more things. I would really need to take more things into account. So, maybe, not always.
One of several options, or
right, because if you think about it, so and what happens is they'll lead up to that Q&A sequence. They'll start talking about heart attack and the cases about somebody who suffered a heart attack, and they're talking about symptoms of heart attack. So they're getting the doctor into heart attack mode, and then they lay out 3 common symptoms of heart attack, but those symptoms could mean anything. Sore left arm. Maybe they just were lifting weights the other day and their arm is sore. Maybe they ran up the stairs because the elevator was broken and they were late for their appointment. So now they're shortness of breath. Chest pain. It could be the exercising as well too. So, I mean, those 3 things could mean many things, but the lawyers use the rhetorical strategy of getting them in the mindset of heart attack, heart attack, heart attack. Yeah, I should have thought heart attack. I didn't. Therefore, I was negligent because this person died or died of a heart attack or whatever the case is. That's not a good example, but
no, it makes a lot of sense.
Yeah, so you would say,
they lay it out like almost common sense, like
how could you possibly disagree with this? So, and if the doctor says no, not necessarily.
Like, that's would you ever drive your car without a seatbelt on? Or would you ever not be wearing a seatbelt in the car? That kind of a question. It's like, well, if I'm in a lake, no.
Right. I'm pulling into my garage.
Yeah, a million things. Yeah.
I mean, there's so many and that's why taking that time to analyze the question and to think, okay, I got to do some analysis here. It's probably not always or never. It's probably somewhere in between. And that's why being methodical about answering the questions is so important, because then you slip in something. And it's not a dishonest way of answering the question. If you say that, not always, that's truthful.
But if you always say it, that could be cagey too. So maybe that's why you have to say yes on the fact things very quickly, right? If they say it was 6:15, yes.
Yes. Yeah. And you don't sweat about it. Right?
Okay. Because that would look bad too. If you're always saying something like that. Right. I don't know. Every single answer would start to make you look a little bit cagey.
No, definitely. I mean, you don't want to, and especially I do not recall. You don't want to start throwing those in there either. And people hate that. I mean, if the truth is I don't remember, that's okay to say. But if you've got do not recalls over and over and over again, and there's something about the phrase do not recall that jurors typically think is a way of getting out of answering the question. I don't remember.
Iran-Contra and Reagan. It goes back to that, really. That was the first I had really seen of it. They made it an art form and they kind of slid out. So in popular culture, I think it seeped into the consciousness as a way to duck.
Yeah, I think you're right. And jurors don't like it. And it's not natural. We don't typically use I do not recall in everyday speech. And it goes back to the point you're making earlier about when people are being truthful, there's kind of a sing-song way about them. They kind of dance a little bit. I mean, you would say, if you asked me a question and I didn't remember something, I'd say, I can't really remember right now. Or I just don't remember, and I'd say it in a way that doesn't seem canned, like I do not recall. That sounds.
My lawyer told me to say, I do not recall.
Right. And it sounds like a way to intentionally get out of it answering a question that you don't want to answer.
All right. Well, we're running way late on time, so I'm going to speed round here a little. Samantha says you have great taste in music.
Oh, sweet. You see my background. Thank you.
Well, that's why you have it.
Yep.
All right. Susan. She's another member. This is awesome. Thank you, Susan.
Human
And-
Behavior Lab. What is
Yep,
that?
she's actually a former guest too.
Okay.
She teaches body language. She does face reading, things of that sort. This is about Amber Heard. Looks like she's on drugs. It's
It could be. I mean, she doesn't
and
look.
I'm not saying necessarily stoned, but maybe like a Xanax or that type of thing. Who knows?
She doesn't look
It's
natural,
stressful.
right? There's
Very, very
something.
true.
Something is going on, and that's the important thing. We don't know what it is, but something is going on, and that's what my goal is to get to avoid jurors thinking that something is going on with this person.
That's true. And it was pointed out that you can't quite tell what she's looking at in the room. Thank you, Triple Crown. Fascinating interview, Eric. The more I hear about the law, the more complex it seems. It's magicianship.
Well, it's unfortunate because witnesses have such a difficult job telling the truth. It should be you get up there, you tell the truth. You shouldn't have to face these strategies that these lawyers, these traps and these tricks that they lay for you to try to trip you up or to box you in or to get you to agree with stuff that isn't true and to make you nervous and anxious and all this stuff. That shouldn't be part of it, but it is. And that's why I have a job. So I can't complain about it because it keeps me working.
All right, I'm going to run with this as the last question. I think it's a good one. It's from wishful thinking. Is there some reason witnesses don't bring reference materials? I would be at a loss without looking at a phone or planner to answer some questions.
Yeah, well, because that stuff can become discoverable for one thing, and that's probably a better question for Viva Fry as well, David. But from what I understand, two points. One is it's not a witness's duty to have everything memorized. You tell what you know, and if you don't know something, you admit to it. I don't know, and that's truthful. So the whole goal is tell the truth, whatever the truth is. And sometimes it's I don't remember. And that's okay. Witnesses really struggle with that, and they feel like, oh no, if I don't remember, I'm going to look like I've failed here, or I'm trying to avoid telling the truth. But the truth is, you can't bring everything with you, and you can't jam everything into your brain. All you can do is talk about what you know, and tell what you know, and be at peace with it. And that's the job of a witness. It's not to have all the answers, to know everything, to hit a home run, to win the case, to fight, to argue, to debate. None of that stuff. I mean, so witnesses a lot of times put way too much on their shoulders. They feel like they've got to accomplish a lot more as they testify, and that makes their job more difficult. So if the answer is I don't know, what day did you do such and such thing? Well, I think it was such and such week, but I can't tell you for sure. I think it was the third week in August.
To produce. It's up to them to produce it then, right? Then they can say, well, it says here, is that possible? And then you can agree or disagree.
Yeah, right. So, yeah, witnesses, they get themselves into trouble when they take too much on their shoulders, and they feel like it's all on them to carry the case, and it's really not. They're a small piece of the puzzle. All they have to do is tell what they know, and that's it. And obviously part of my role is, you tell the truth, but you also learn how to tell the truth when you're being scrutinized and cross-examined by a very aggressive lawyer or a kind lawyer or whatever it is. How do you tell the truth? How do you keep the demeanor, the confidence? How do you demonstrate confidence? How do you come across in a way that's jury friendly? The jurors will like you, they'll want to believe you, then they'll trust you. And that's what it is. So, I try to reduce the role of the witness to very few fundamental things, and that's telling the truth in a way that the jury's they're gonna keep listening, and they're gonna like listening to you.
Well, while I have you pinned down to where you have to tell the truth, are you going to be back to do more of these?
I hope so.
All right, Jeff. Thank you so much, and everybody. If you like people like this, Viva Fry's coming next week. I have 2 members of the behavior panel coming back next week as well. And we'll have to get Jeff back here sometime. We barely even started on the videos we have.
Yeah, we always get off on tangents, but I think it's interesting to me. So I always feel like maybe I'm saying too much, but to me, I find it interesting. Hopefully other people find it intriguing as well. So it leaves us more content for the future, right?
All right. So everybody hit like, hit subscribe. Please come back.